Any mention? Daily list, item number 1. Daily list.
Okay, daily list.
My Lord, I am informed
One second, let the file come.
You are appearing for emboss?
My Lord, the learned senior is appearing for the impose today, my Lord. Subject to
Yes.
Lordship convenience if the matter fixed next week for admission. Subject to Lordship, otherwise 10 days.
You enter appearance today only enter appearance, correct?
Yes.
Let them put it, yes, or after 16.
For the emboss.
Or after 16 August. Yes, sir. Where is that?
Of course.
Footnote indicates that this point number 7 just entered appearance through Mr. Mr. S.P. Mantan is counsel with El Samar present. Such service complete on all the respondents. Prayers made for listing the matter.
A week.
After 2 weeks.
After 1 week, if Lordship.
After 1 week.
My Lord, yes.
What happened? The orders against you?
The order is against me. My writ is dismissed.
Out of service?
He is out of service.
Yes. MSA Paul. They are asking for after 2 weeks, 1 week. 1 week. Yes, sir.
All right.
List the matter. After 1 week, yes.
For
admission hearing.
Yeah, admission.
Yes.
Supplementary list, item number 1.
Notice? 19 days. Notice was
Well, this is an appeal against the order passed to learned single judge, my lord. But here what happened, my lord, the respondent applied for the post of staff nurse, my lord, in the Assam Rifles, and it was found that she is having LASIK surgery. So the LASIK scar was there. And in terms of the rules, LASIK is not permitted in the Assam Rifles, my lord. The learned single judge held that to appoint her on the ground that the doctors who are the gazetted officers with LASIK are permitted in the Assam Rifles.
They are having LASIK scar also, the doctors?
My lord, the rules permit, my lord. We do not know whether there are actual cases of LASIK surgeons or doctors in the Assam Rifles or not, but the rules permit that gazetted officers can have LASIK surgery, but the lower staff, my lord, they call it other ranks in Assam Rifles, they cannot have. Now, my lord, our case is that horizontally there can be classification, my lord, because what will happen otherwise, nurses are in grade C, my lord. Now, if you have in general duty or operator radio line or other category also have to accept people with LASIK, my lord, that will have very drastic consequences, my lord.
So the other cadres also accepted? Or for group C service, no?
For B and C, it's not accepted for any of the category. Okay. Only for A is it. So, my lord, there's a horizontal line, my lord, there's a commandant, then assistant commandant, the rank wise, my lord, and there's a vertical classification.
But that is surgery corrects, I mean, the vision to 6 by 6. Is it correct? Is that not correct?
It correct, my lord.
Then?
But the rules say so, my lord, that for...
the rules dispute medical science.
Grade B and C will not be permitted, my lord.
Yes.
And the learned single judge directed that till the respondent appointed, no further appointments of nurses will be done.
Upon no further appointments as nurses.
My lord, if I may take your lordship to the last page operative part of the judgment, my lord. The last parameter, it is made clear, your lordship.
Is made clear appointments?
No other nurse will be appointed.
Who appeared for the
Mr.
petitioner before the single judge?
Mr. Pathak appeared. B. Kumar and Pathak. The notice has to be served.
Issue notice.
There's a delay also, my lord.
You can take down MCW 82124. Stop. Just an application for condemnation of delay of how many days?
89 days.
Of 89? Of 89 days in preferring the incident appeal. That issue notice to the respondent within
3 days.
Within 3 days. This matter after 2 weeks. Yes, for orders.
Deeply.
Yes, 5 minutes. Sorry.
Any mention?
My Lord, I beg to mention hearing number 23, the last second item.
Which one?
Hearing number 23, ma'am.
Respondent 6.
We are appearing for respondent number 5.
6.
Number 6.
Why?
Number 6, my Lord. We have informed to learned counsel for the other side also.
Yeah,
We
Chandra.
have been informed. Lordship, my
What's the
senior is
problem?
also here.
My Lord, I have some personal difficulties. Matter may be taken up after 1 week.
1 week.
After 1 week.
Lordship.
Subject.
Yes? No objection? 1 week, okay.
1.
On the prayer, which is appearing for respondent number?
6. Number 6.
Number 6, yes.
Give the objection.
Yes.
Lordship, I beg to mention item number 18, Lordship, of the main list, Lordship.
Where's the Jindal?
Lordship, I have informed.
I'm here.
He's here. Oh,
1 week's time, Lordship, I am seeking. Lordship.
Apparently the senior is not in station. So.
Difficulty, Lordship, on the part.
who's the senior?
Lordship, he's out of station, Lordship. He's
Mr. Hapa or Mr. Paul?
Mr. Paul, Lordship.
Okay. Right. 1 week, yes. Yes.
My Lord, seek a permission to mention item number 16, 16.
My Lord, I am appearing for respondent, my Lord. Interim order is in favor of my friend. So if Lordship convenience, may be fixed as a fixed matter next week, Lordship.
I need some time to better prepare. Considering my opponent, I need to be fully prepared. A week or 2 weeks, my Lord.
After 10 days, as a fixed item, Lordship fix the matter.
Has no meaning, which one, so? Fixed items. All these are fixed items, actually. They're prefixed. Okay, 2 weeks, yes.
All right.
Please do it. I mean,
Yes.
I'm not going to impress upon the lawyers. Like, just try to, matters to try to finish as many as you can. Yes.
This one on the next date. All right.
Much of.
Please, Lordship, I beg to mention item number 24. One week's time, Lordship. I've already informed the council.
Who's for the other side?
Your Lordship, I'm appearing on behalf of the conducting counsel, Mr. Al-Karim, for the petitioner.
No objection.
No objection, Your
1
Lordship.
week.
1 week.
Okay, 1 week, yes.
Much obliged.
Yes, yes, yes.
May please, Lordship, I beg to mention item 17. And for respondent number 1, Your Lordship. I pray
Your
for 2
objection?
weeks' time, Your Lordship.
What's happened to Mr. Gautam? He's sick.
Your Lordship, not Mr. Gautam, but his brother, Your Lordship, Sir Keshav.
Who's his brother? His
Sir
brother's
Keshav.
sick also?
His brother is sick, Your Lordship.
No, which, this is the one who's, this one is Keshav, one's Kishore. Who's sick? Kishore or
Sir
Keshav?
Keshav, sir.
Kishore is sick.
Sir Keshav.
Then you take on whose behalf?
I'm taking on behalf of Sir Kishore.
Where is he? He's not sick. Why he's not coming for the hearing?
Lordship, he has some personal difficulties.
1 week, yes.
Obliged.
Your Lordship, similar prayer for item number 15, Your Lordship.
Any interim order in your favor?
No,
No, Lordship.
No. Okay. 3 weeks, yes.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item 20, Your Lordship. I have taken the consent of the other party. May it come after 2 weeks, Your Lordship?
It'll be 3 weeks, Your Lordship, then.
4 weeks, yes.
Lordship.
Highly obliged.
Obliged.
Take it easy. We'll give you long adjournments now. Once you mention 6, 7 weeks. Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 11.
11.
Yes, Your Lordship. We have already informed the opposite party, Your Lordship.
This matter, where's Mr. Kharshian?
We have already informed him, Your Lordship.
This matter could. Okay, 1 week, this one, yes.
Similar prayer to item 13, Your Lordship.
What is wrong? Why are you joining all the cases?
The senior conducting counsel is indisposed, Your Lordship.
Okay. 1 week, yes.
Much obliged, Your Lordship.
13.
Yes, Your Lordship. 1-3.
Yes.
I beg to mention item number 10, Lordship, of the main list, Lordship. Okay. Lordship, I'm praying if this matter can come up next week, Lordship.
Lordship,
10 is connected to number 9.
9 and 10 are connected.
Yes, Mr. Padhak.
Because since Mr. Paul is not there, but then there's a slight difference between the two matters. But anyway, since they are dead, my lord, we probably have to wait there. In fact, the identical matter, my lord, we had placed. There was a matter in Kerala High Court. In fact, today for filing of response of the Assam Rifles, it is fixed also in Kerala High Court today on the same issue.
No, we'll see after 1 week.
My lord, the Kerala High Court has basically said that compliance is not full, so therefore an additional report was directed to be filed.
Okay. Yes.
1 week, Lordship.
Hello,
Lordship.
Your Lordship, I beg to mention item number 22.
This is too much. I mean, I think we'll stop this weekly list business.
Kindly pray for 2 weeks' time, Your Lordship.
4 weeks, yes. I pray, yes. Yes?
Be obliged.
Please, Your Lordship, I beg to mention item number 21, Your Lordship. I pray the matter may come up after 4 weeks.
21, you want?
21, Your Lordship.
You have a petition, you have urgency.
So, the conducting counsel is unwell.
Who's going to counsel? Ding Dong?
AP Carso not, Your
Who's
Miss
done
AP Carso not, Your Honor.
Who?
AP Carso not.
For which
For the
respondent?
Dolbar, my lords. For the
Respondent number 1 and 2.
Okay, 2 weeks.
Obliged, my lord.
Yes. That's it, yes.
May I please Your Lordship, I beg to mention item number 19 on behalf of Sir R. Shah. He went for his review checkup, Your Lordship, so I pray for 2 weeks' time.
3 weeks, yes.
Highly obliged.
On for negotiation. Put it to... Yes.
To mention item 14.
Number?
14. Lordship, I have
What
instructions.
do we have?
Petitioner, Lordship. Lordship, I have instructions to withdraw this matter, Lordship.
Okay, withdrawn. Yes.
Obliged, Lordship.
Hafizur Rahman.
Lordship.
Yes, on the prayers also, on instructions. It is a matter of withdrawal. No liberty.
No, Lordship.
Withdrawal is according but as far as close. Withdrawn, yes.
Highly Lordship.
Yes. Hello.
Supplementary list, item number 1.
May it please Your Lordship. Lordship, you may kindly take up this matter at the end of the board.
Let's what's out here. What's the matter about?
Lordship, we are here before Your Lordships with a small prayer, Lordship.
Yes.
Lordship, if Your Lordship is pleased to come to page 8, which is the list of dates, Lordship.
Page 8.
Page 8.
Page 8 so what? Is the?
My list of dates, Lordship, page 8.
Yes.
Lordship, what has happened is, my lord, that against the petitioner there is a pending CBI case as well as a departmental inquiry. He is a postal employee. Lordship, we had come before Your Lordships earlier challenging the departmental inquiry, but seeing that the matter pertained to CAT, Lordship, at that time the bench was not there at Guwahati. Lordship had passed some protection so as to allow us to approach the CAT immediately.
Yeah.
Thereafter, we had approached the CAT, Lordship, and all the pleadings have been complete. In the meantime, what happened, my lord, because since the matter was pertaining to disciplinary proceedings, it was supposed to be taken up by the division bench of the CAT. But the division bench of the CAT was not constituted at that point of time, which is why we came with a second round of writ petition, Lordship. Thereafter, Lordship, in the month of February 2023, the bench had been since constituted, which is why Lordship was pleased to dispose the matter, allowing us to...
No, over 1 year. What happened now?
Now, thereafter, Lordship, what has happened is since this matter pertains to the Shillong state of Meghalaya, the CAT has placed the matter before the Shillong circuit bench, which sits once in 3 or 4 months, Lordship. Now the matter was fixed on 2nd of May 2024 for final hearing, but it could not be taken up on that date. Now it has been fixed on 26th of August 2024 for final hearing with regard to the challenge to the disciplinary proceeding.
Yes.
In the meantime, Lordship, over the course of the last 2 months, petitioner has been receiving numerous letters from the inquiry officer asking him to come and give his statement in defense. So we had replied to them, Lordship, to keep the disciplinary proceeding in abeyance till 26th of August, if any, whatever. Why? So that, my lord, because the basic grievance here, Lordship, is that...
We can't attain why you filed application before this and after to...
Because it's placed before the Shillong circuit bench, Lordship. So I'm only praying for a small...
You can file an interim interrogatory application. Why?
No,
we can't see one thing, Mr. Dev. We can't just go again, and intrude.
I understand the
First, we already have sent it to the Sanskrit tribunal, so we can't now in the middle pass orders again.
I understand the limitations.
Proceeding in the in the proceedings.
No, because why? Because he has been called to come tomorrow to give his statement, Lordship.
Sorry.
So only till tomorrow. We'll mention the matter on Monday, Lordship. We'll file an application in Guwahati. Some constraints are there, Lordship. We're praying for a small
And there's
relief.
nothing to hard and fast. No stay order. We can't intercede. We can't in the middle. How
Only
can we?
Only tomorrow's thing may be kept in a
Yes, we're not going to obtain an application at all. Yes, Dr.
But the matter is pending before CAT, my lord.
I'm only praying for that tomorrow's date.
File it before CAT.
This should file before CAT. Moreover, my lord, the charge series is to 2020, my lord. The memorandum of charge in the disciplinary procedure of 2020. To stay any part of proceeding at this stage, my
I'm
lord.
not asking for any stay, Lordship. I'm just saying that on 19th, I may be exempted
See,
from
Mr. Dev, why? What prevented you from filing an IA before CAT? Maybe the matter is fixed.
because-
Circuit bench. The records are there.
No, Lordship, what has happened is, Lordship,
They
petition
filed an
is
adjournment
around-
before the inquiry authority also.
petitioner is about 75 years old. He has to go to and file it in Guwahati. So that is why we have immediately come with this, because he has received the letter only this week, Lordship, to attend the hearing tomorrow. I'm only praying for this small indulgence, Lordship. Nothing, no stay,
We're not
nothing, Lordship.
entertaining it. We're not entertaining it.
Only tomorrow's, because they are not accepting our...
It is the end of the board. We hear the end of the board. Again, you take instructions from your client. Say the court not inclined to entertain the petition, and it will be dismissed.
Lordship, if I may pray, my lord, only tomorrow's date may be exempted. I'll file my application on Monday itself, Lordship, for expedited hearing of the matter, which is fixed on 26th.
When did he get a notice?
Lordship,
Where is that?
Lordship, may be pleased to come to page number 92.
5th July. my lord.
He dated
5th July,
5th.
Lordship.
Then?
5th July. He was
when did you receive it?
received on 5th itself, Lordship.
Then
He's been asked to come tomorrow for his final hearing.
where do you come the last moment then?
We filed it on 16,
So you
Lordship.
take
because of-
instructions. We'll hear it again after. Follow. You withdraw it, otherwise we'll dismiss it.
Item number 2.
Obliged.
Yes. What is this?
Well, this is for extension of time, my lord, for compliance.
Where's the order?
But the operative part is at page 12, my lord. Para 8, my lord. Given copy. 8 weeks time was granted, my lord.
Where's the petitioner? MSP Agarwal.
My lord, appearing in questions. My lord, we need to file objection.
Why?
Because after the judgment was filed by the Honorable Court, the respondent authorities have issued a fresh advertisement for remusteration. And the petitioner was also called ARTC and S. Mahmood to appear in the exams which he has already qualified. So the documents from ARTC and S were sent to the Director of Exam Writers below.
You file then. Is that correct? If it's a direction of remusteration, and why do you float a fresh advertisement?
My lord, kindly see para 3 and 4 of my application. In fact, the case has been half processed, my lord, already.
Half processed?
My lord. It is under process, my lord.
Have you served copy? Have you received copy of this application?
They should in fact be happy with this, my lord.
Okay, what do you have to say? Yeah, wait. Yes.
Para 4, my lord. Thereafter, the case was processed and the law branch of Assam Rifle concurred with the legal opinion so-and-so and recommended that the judgment and order be complied with and age waiver be granted to the writ petitioner as one-time measure in order to enable the writ petitioner to undergo the remuneration process, and the same was approved by the Director General of Assam Rifle that as per the directions of the Honorable Court, the candidature of the petitioner has been reconsidered for relaxation of the upper age limit for remuneration so-and-so, and age relaxation has already been granted. However, the completion of the remuneration process involves several stages, including assessment of its fulfillment of other conditions of remuneration, and it will take some more time to complete the remuneration process. So, my lord, your lordship is only directed to grant the age relaxation, my lord. If I may read para 8 of the order passed by lordship, my lord. Para 8 says, my lord, the respondent shall therefore reconsider the candidature of the petitioner for relaxation of the upper age limit for remuneration as SKT. That was the direction. In fact, we have complied with the direction, my lord. And the age relaxation has already been granted. The next stage, the
That
direct.
means that you're not reconsidering him for remuneration. You relax his age and throw him out.
My lord, then he has to meet the other criteria. My lord. When
What
earlier,
other criteria?
whether he fulfills the remaining criteria, so many
Why
years.
is he taking time to make sure he doesn't fulfill other criteria?
No, my lord, that cannot be the intention, my lord. Well, in fact, what I've been told that his case is.
1 second, I'll hear you.
His case will be done, my lord, but
Yes.
only we need some time.
Yes. Say what you have to say.
Lordship, your
Yes.
Lordship will facilitate one fact. The selection process is under. There are other acts who have applied in the press advertisement issued on 6th of June. The petitioner has also applied. Now, if the extension is granted with regard to the petitioner's case, all his juniors will supersede him, my lord. And the entire exercise right from.
No. 1 second. 1 second. Now, were you compelled to apply again? Is that a case?
Yes,
her
my
case?
lord. Yes, Lordship. We have to apply again.
Now your case that you already passed, you're eligible for remuneration from the earlier exercise. Only that age like you also overaged. Correct?
But if I may just place the facts, my lord. Well, earlier when the remuneration process was done, my lord, he being overage, he was disqualified.
Right.
So 8 candidates, if I remember correctly, my lord, were selected. He was not one of them, and they were sent for some training, my lord. The respondent herein has already completed their training. So that's why the lordship said that only since he has already completed the training, so a few months age relaxation should have been given to him, because others will be doing the training now.
Yes.
Now, that being the case, my lord, his age has been relaxed, my lord. Now, only certain, whatever the formalities are to be completed, that is to be completed.
But is it a given that he be remastered?
That's what I have been made to understand, my lord.
He'll be remastered.
He'll be remastered, my lord. Because age was the only hindrance at that point of time, my lord. There was no other.
How you will give? When can you complete this? In 2 weeks?
Asking for 2 months, my lord. At least 1 month time is given, my lord.
You will give them 1 month's time. If any fresh call of action arises, then you come with a fresh petition. Yes.
The Lordship will appreciate one fact. 1 month time.
My lord, I am praying for 4 months time, my lord. Sorry.
These 7 vacancies will be filled up, and the people who are junior to me, those candidates will supersede me, my lord. The seniority will.
See, whatever. See. Listen. Please listen. Whatever it is, sitting here today, it is on these respondents to complete the exercise. Correct. What's the outcome of the exercise? That we'll see. That you will see. The petitioner will see. The only thing they're asking now is for some further time to complete exercise. So, court grant them 4 weeks. It closes this case, and then you see after that you take whatever steps necessary. And if they've given the undertaking that he'll be remastered, let's see what happens. Yes.
But in fact, the prayer was for 4 months, my lord.
4 months. No.
Well, it's 2 months is given, my lord.
Okay, 2 months then. 8 weeks. Yes.
Now it's already 4 months, my lord.
This is
Judgment was
passed on.
passed in March, my lord.
Then you're in contempt.
The judgment was passed on 22/3/2024, and they have come before this court in the month of July, after 4 months.
My lord, my friend should not be hyper-technical. As I submitted, my lord, the direction was only to condone the age. That we have already done, my lord. That's what I was trying to point out.
Okay, just take down.
There's no further direction to remaster him, my lord. The direction is only to condone him.
Number 128, yes, 1/8/2024 and WPC number 464 or 2022 bracket disposed of. This is an application for extension of time for compliance. With the judgment and order dated 22/3/2024, passed in WC number 464/2022. Stop. Next, by Dr. M. Mozika, learned DHI with so-and-so submits that the age of the petitioner since been relaxed as per the directions contained in the order dated 22/3/2024, and that what remains only for the final reconsideration. With regard to his remuneration. Stop. He further submits, as the process is still taking some time, he prays to be allowed 4 months further time to complete the same. Stop. Next paragraph. MSP Agarwal, appearing for the opposite party petitioner, has vehemently opposed the prayer of the learned senior counsel, prayer of the respondent, and submits that enough time has been given, has been allowed, and they have come belatedly with the application. Stop. Next paragraph. Consider submission notwithstanding the objections of the consulate petitioner. Stop. The respondents are granted 2 weeks,
2 months,
2 months further time from today to complete the entire exercise. Stop. Matter concerned disposed of. 2 months. Yes, enough. Yes. Next matter.
Daily list, item number 1.
Yes, Lordship. This is a contempt, Your Lordship. My here submission is that let the respondent show that any payment made after the passing of this order, because their claim, Lordship, my only humble submission is that it's a false claim, because whatever payment that is done, that is prior to the order passed by this honorable court. This order was passed on 4th 2023. Thereafter, there is no payment. And there's whatever in the affidavit they have stated that they are claiming that they have made some payment. That we got it, that money that is prior to the order passed by this honorable court. And after that, for 1 year they have not paid the salary. Again we come back to the court, and this instant order was passed. And after this order, not even 1 rupee or was paid to the petitioner. So they're
You
trying
file
to...
affidavit, right? You file affidavit. What do you say?
If your Lordship is pleased to come to our affidavit, Lordship.
Now, just remember that he said that after
the
4/8/2023,
order, yes.
they have not been paid a single rupee.
Lordship, yes. Lordship, may please to come to page number 13 of my affidavit.
Page number?
13, Lordship. Annexure 3 in series.
Page number?
Page 13, Lordship. Annexure 3.
Yes.
Lordship, these are all the payments which have been made. If I may take your Lordships to each of them. Page 13, Lordship. This is the arrears. Amount is rupees 1,53,000, Lordship. Paid on, Lordship will kindly see the signature on the right side. 1/2/24. 1/2/2024, Lordship.
Where's his name?
His name is number 3 and 5. All of them are there, Lordship. Thereafter, Lordship may kindly come to the next page. Page number 14. Lordship, for the month of June, July, August 22, amount of 24 lakhs. Lordship, the date has not been mentioned here. I am under instruction, Lordship, that this was paid on 31st January 2024. They have sent us the check.
See, one thing, Mr. Sangma, is
Yes,
like
Lordship.
this now. Maybe the payment will maybe for the periods before 2023, but the payments were in 24.
Lordship.
So
again at page 15, 16 and all.
Others,
Around
except
50
this
lakhs.
page 13, that I'm not...
Around 50
we have
lakhs.
not seen this. We have not seen the annexures.
But when verbally, when they have asked me, they have not paid anything, because that payment was made prior to that order. There was an order also.
What did your petitioner tell you?
They said they have not received after the order of this passing of this order.
They have not received anything.
They have not received anything. That is the instruction. That my
What if this chart shows that your names?
maybe let him. I will send it this copy. Let him have an answer. Otherwise, Lordship, only this. Otherwise, they said.
You have any new cause of action? You file it. Then.
We have paid around 50 lakhs after the passing of the
Yes,
order.
anyway, the instant contempt application has been filed alleging violation of the order dated 24
4/8.
24/8.
4th.
What is that? Alleging non-compliance of order dated 4/8/2023. Stop. Next paragraph. Mr. P.T. Sangma, Council Petitioner, submits that the respondents have committed contempt in as much as after 24/8/2023, no payments have been made whatsoever. Stop. Next paragraph. Mr. S. Deb paying for the respondent. One respondent or two?
Lordship, 2, Lordship.
For the respondents has drawn the attention of this court to the affidavit filed on behalf of the said respondents, wherein at annexures 3,
all marked in series, Lordship.
3 series, it is noted that the writ petitioner whose name appears still number 3 had received payments on 1/2/2024 and thereafter again.
Lordship, on 3 dates payments were made, if I may just give the dates,
And
Lordship.
thereafter
1st
on
February, 31st January and 14th.
and 2 other dates.
Yes.
Stop. He submits that the allegation of violation of the court's order is misplaced in as much as the respondents are doing their utmost best to pay the arrear salaries of all the petitioners. Stop. Next paragraph. This court has noted the submissions, also perused the statement of payment as annex. It is seen that though the payment has been made on 1/2/2024, the amounts relate to arrear salaries which were pending from the year 2022. Stop. In his view of the matter, though arrear of salary is still pending, stop, as there is no willful violation of the orders of this court, the contempt stands closed in disposal of. Yes. That's
Obliged, Lordship.
Item number 2.
Your Lordship, 3 weeks' time may be granted to file the rejoinder, Your Lordship.
You already took time last time. Yes, further 2 weeks' time as agreed by MSP Sunar. Allowed for rejoinder. Yes, thereafter. 2 weeks.
Item number 3.
Lordship, in this respect, we have sent a notice to the private respondent. Your Lordship, you have taken the step has been taken. I think the private respondent still awaiting for service report. Otherwise, we have already complied and we have already sent it on 28/6/2024.
Office note indicates that the service on respondent ones are complete. You want to file service affidavit?
Yes, Lordship.
Stop. Mr. P. praise funds allowed to obtain status of service and to file affidavit.
Lordship. Lordship.
Much obliged, Lordship.
Yes, up to 2 weeks, yes.
Item number 4.
Please, Lordship. Lordship, I pray for some time to file my affidavit, Lordship.
What's the matter about?
Non-payment of salary, Your Lordship.
Which department?
PWD, Lordship.
PWD.
Retired? Oh.
Not yet, Your Lordship.
See, it's also a serious matter. Person's transferred, now not getting his salary.
Lordship, as per what the instructions I've received, Lordship, he's not working in a sanctioned post, Lordship. He's a work charged employee.
Now, where did you
So there was
transfer
some discrepancies while he was transferred, and Lordship, I'll file my affidavit, Lordship.
You got instructions?
Yes, Lordship.
Mr. H. Konara submits it. Praise he will allowed for 2 weeks time to file. After praise allowed this up to 2 weeks, yes.
Item number 5.
Lordship, we have received instructions. We just need 2 weeks' time, Lordship, to file a affidavit.
Your
What's the matter about?
Your Lordship, this is regarding appointment.
Appointment to?
School teacher, Your
School
Lordship,
teacher,
assistant teacher.
Yes.
You're a fresh appointee or working and terminated?
This is a
No,
fresh
she
one,
was
Your Lordship.
not terminated. She was.
Who are you?
then I'm the private respondent because he is challenging my appointment, Lordship. Should I be filing a
Oh, yes, the one regarding the marks.
Because
Yes,
this
the
order,
bonus-
I was
bonus
appointed on the
marks.
basis of the High Court order because there was a writ petition. Court has directed, government has approved my...
Have you filed affidavit?
I'll be filing because some difficulties in Lordship, that's why I'm not the only similar prayer I'll make.
Yes, MST Young England AG with so-and-so, MSP
1, 2 and
Sangma
3.
for 1, 2 and 3, and PT Sangma for 5, pray for allowed for the 2 weeks time to file affidavit.
Your Lordship,
Yes,
with
sir,
regards to respondent number 4, I may be allowed to obtain status report.
Who was there also?
Yes, Your Lordship, managing committee, Your Lordship.
Yes, MS Akashing praise funds allowed to obtain status of service upon respondent number 4. Just accordingly, yes.
Item number 6.
Please, Your Lordship, we have taken steps on respondent number 3, yet to file the affidavit of service, Lordship.
Lord, we are also awaiting instructions, so I'll pray for some time.
Yes, Mr. S. Deb praise allowed to obtain status of service on respondent number 3. Mr. Kivarachaji praise funds allowed for response number 1 and 2.
1 and 2.
Praise for the 2 weeks to file affidavit. Praise allowed, yes.
Obliged, Madam.
7.
May it please Your Lordship. Your Lordship,
Yes.
I'm appearing on behalf of Mr. N. Simcon
One
for the
second.
state.
Lordship, I have filed my affidavit in service on 16th of this month. I have filed my affidavit on service.
Indicating service?
Yes, Your Honor.
On respondent number 7.
7, 8, and 9.
Okay. An affidavit indicating service on respondents 7, 8, and 9 has since been filed by the petitioner. Such service upon Mr. Respondents is complete. Stop. What do you want?
Sometime, Your Lordship, for respondent 126, Your Lordship.
Is it regarding VEC? What's the matter about?
Yes, Lordship, it's regarding the PSC only. We have challenged the inquiry report.
Where's the other matter? Who filed that? This you filed it only.
Yes, Lordship, it's different matter, Lordship.
It's not the same VEC.
It's regarding the same PSC, Lordship, but it's
What?
different matter. Lordship, here is the inquiry. Inquiry against the inquiry against the report of the job card. Inquiry against the report of the job card.
Is it regard to the voters list?
No, Lordship. Here, misappropriation of the fund. We have filed application representation for misappropriation of the fund. So we have inquiry against the BDO, but it was inquiry was held against the lease.
Oh, different matter.
Yes, different matter, Lordship.
Okay, Ramna? Yes. But MS Islandwa, the council for 1 to 6, please for the further.
2 weeks.
2 weeks time to file affidavit is. Just thereafter.
Obliged,
Just
Lordship.
thereafter for affidavit for appearance of respondents 7, 8, and 9.
Item number 8.
Your Lordship, in terms of the last order, Lordship, respondent number 3 to 6 were supposed to file their affidavit, Lordship.
Your Lordship, I am praying for some more time to file the affidavit in opposition, Your Lordship.
When is the matter filed? And MS prays for the Lord further 2 weeks time to file affidavit list thereafter and so on.
Second call, supplementary list item number 1.
You received instructions?
I'm under instruction, Lordship. We'll withdraw with liberty to approach the cat.
Yes.
Only tomorrow's small indulgence will be granted, Lordship. Only one day, Lordship. Or by Monday, we'll.
In that case, let the matter be pending, my lord. I'll instruct them the matter is pending. Don't do anything tomorrow.
On 26, Lordship, if no outcome from the CAT, we'll participate.
Or it will be better if they can file a simple adjournment. I'll tell them not to do anything.
We'll do that.
If I'll adjourn for dispute proceedings.
We have done that, they are not accepting, which is why we
I'll
are
instruct off the record. Yes, Mr. S. Deb submits that on instructions we permitted to withdraw the incident application and to prefer an appropriate application before the Central Administrative Tribunal at Guwahati.
Or before the disciplinary proceedings.
Or
also.
before the disciplinary authority, as the case may be. Stop. On these submissions, which is objected to by Dr. N. Mozika, Learned Counsel for the respondents, the matter is allowed to be withdrawn. Stop.
They may consider my adjournment.
I'll tell them. You file an adjournment there.
We'll do that.
Obliged.
Matter also has to be withdrawn, yes.
Supplementary list, supplementary hearing 3.
Something else, it's already hearing. वही बता दिया तो कम देगा ये आधा सब तो कम आ जाए Yes.
My learned friend has relied on the judgment of the Supreme Court, my lord, and that judgment, my lord, I have gone through, and that judgment is entirely on different issue. It has no, in my understanding, my lord, according to me, it has no bearing, my lord. This 1960 SCC online SC27, my lord.
1961 is Supreme Court, page.
Yes, one SCR 341, my lord.
Yeah, 61 SC4.
Yes,
yes,
sir.
Yes.
This is the judgment which was relied by my friend.
Yes.
Who canvassed the point that the standard operating procedure cannot be laid down by the state government.
Right.
Now, my submission, according to me, my lord, the challenge in this case, my lord, was to the virus of the notification issued and given to the Act, my lord. And the Honorable Supreme Court, the Constitutional Bench upheld the virus and notification both, my lord, issued under the Act. How it is helpful to my friend, I don't understand, my lord. I couldn't follow.
Does see the operative part?
Yes, my lord, kindly come to paragraph. There are two arguments, my lord. First, you will also will see paragraph 7.
Yes.
Broadly stated, your lordship, my paragraph is
same.
Paragraph.
Yes.
Broadly stated, section 6.2 seeks to provide for fixation of a lower rate of maximum rent area-wide. We have already seen that individual tenants are given right to apply for fixation of reasonable rent under section 12 by section 12, and specific factors have been specified which the Mamaltadar must consider in fixing reasonable rent. The legislature realized that large number of tenants in the state were poor, ignorant, and in many cases helpless. It was thought that many of them may not be able to make individual application for the fixation of reasonable rent under section 12. That is why it was thought necessary to confer upon provincial government the power to fix lower rate of the maximum rent payable by tenants in respect of particular area. In a sense, what could be done by the Mamaltadar in individual case can be achieved by the provincial government in respect of large number of cases covered in particular area. If that be so, the legislative policy having been clearly expressed in the relevant provisions and factors for determining the reasonable rent also having been specified in section 12, it is difficult to accept the argument that provincial government has been given uncanonized or unfettered power by section 6.2 to do what it likes without any guidance. The relevant factors have been specified in 12.3 and my lord, at the bottom of this paragraph 7, my lord, last 7 lines, it would not be possible, 4 lines, my lord, it would not be possible to hold that power delegated to the provincial government by section 6.2 suffers from infirmity of excessive delegation. The fact no minimum has been prescribed would not materially affect this position.
Yes.
This judgment, my lord, great respect favors me, my lord. And if I can take your lordship to the scheme of the Act, my lord, can you see the Act itself? Act has given so much discretion to the state government and union, my lord. And the provisions of the Act is not under challenge before your lordship. Can you see section 5, my lord? Section 5 of the MMDR Act.
Yes.
A restriction on grant of prospective license of mining leases, Your Lordship, Section 5.
Yes. Yes.
A state government shall not grant a reconnaissance permit, prospective license or mining lease to any person unless such person A is an Indian national or company defined in clause 2 and so Companies Act satisfies such conditions as may be prescribed. Kindly mark this line. Provided that in respect of every mineral specified in Part A and Part B of first schedule, no reconnaissance permit, prospective license or mining lease shall be granted except with the previous approval of central government. So this coal mineral fall in Part A. Coal falls in Part A, Milord. I will show the schedule also.
Yes.
Then, Milord, the third condition, in case of form association, we are not concerned with individual, Milord. B, no, two, Milord, no mining lease shall be granted by the state government unless it is satisfied that there is evidence to show. B, Milord, there is a mining plan duly approved by central government. C, Milord, in accordance with system, provided that mining lease may be granted upon filing of mining plan in accordance with system established, Milord. So, my first contention is, Milord, that the 5(1)B, Milord, clearly provides for satisfies such condition as may be prescribed, Milord. So there is a power vested in the state government to prescribe the conditions, Milord. That is my independent power under 5(1)B, Milord. If this argument is upheld, Milord, this argument is accepted, Milord, and may not go to Section 18, Milord, where central government has also been conferred with the power to issue necessary direction, Milord, for granting mining lease, Milord. Kindly see section, there is a power conferred on the central government to issue necessary direction also.
Yes, where is that?
Yes, Milord, that power is, that section is there, Milord. I will take. Because these are the powers vested in the state government, and power to make rules is there, Milord, in section 15, Milord. That section is concerning minor mineral, Milord. And then, you know, kindly give me a moment, there is a power also. Section 20, capital A, Milord.
Yes.
Power of central government to issue directions. Notwithstanding anything contained in this Act, central government may issue such direction to state government as may be required for conservation of mineral resources or on any policy matter in national interest and or for scientific and sustainable development and exploitation of mineral resources.
So you mean to say that under this section 20A, when that meeting was held with the Ministry of Coal, that they examined the local conditions and said that they should minimum area should be 100 hectares.
Yes.
So you mean it's under this under a power given.
Scientific and sustainable development of mineral, Milord. Kindly see the minutes also, Milord, of my counter.
One second. Mr. Sangma, you know the arguments also we have to make replies. You have to rebut the arguments.
Yes, Your
if
Lordship.
we're not in agreement. Otherwise,
Yeah, I am ready, Your Lordship.
especially the judgment now. Now when you place the judgment, you read only selected paragraphs. We were under the impression that in the delegate legislation was the piece delegate legislation that was given in the judgment was disapproved. But then after you read the whole judgment, it shows that the Supreme Court said that no, it's all right. Then
Not all right, Your Lordship.
yes. Anyway, okay. Yes. Let's go to your counter.
Page 10 of my counter affidavit, my lord.
One second. Number 1 and 2.
Yes, my lord, number 1 and 2 at page 10.
Yes. Yes.
The various discussions are there. Why, what your lordship has already noted in paragraph 5, the technical input given by Director PND and CMPDIL, and request it was reduced to 100, and then direction, my lord, paragraph 9.
Yes.
It says, my lord, in view of the discussion held during the meeting, JSPNS stated that state government would prepare an SOP for processing of these cases by including the following, among other steps to be decided by state government. Then, my lord, as already my lord, scientific next page, as per discussion, minimum mining area of 1 square kilometer should be considered for prospective license. State government may consider to do this, to consider 2 more. So minimum area is 1 square kilometer, which is 100. This is the direction, I would say, under capital section 20 capital A. If this is not a, even assuming, my lord, this is not a direction, my lord, even under section 5, the lease can be granted by the state government on terms and conditions prescribed by the state government. SOP, my lord, can be treated as terms and conditions. Now, in this light, my lord, kindly see all the Masa judgment, my lord, that my friend has 2019 judgment, my lord, because the entire discussion is there in all the Masa, my lord. 2019 8 SCC 177. Paragraph 91, my lord.
Yes. 1 second.
When under a parliament,
Yes.
when under a parliamentary enactment, the state has been given some statutory obligation. There is no lack of jurisdiction in the state to frame policy, to give effect to or implement the jurisdiction conferred on the state by parliamentary enactment. It is true that mining policy to be framed by state government has to confine to the jurisdiction conferred on it as per MMDR Act 1957 and rules framed thereunder. There are other related issues concerning mining like protection of environment and forest, for which state has to declare its policy for implementation of its objective. Several other aspects relating to mining like rehabilitation, reclamation, restoration have to be effectively implemented by state government, for which also it may be required to frame a policy. May further notice that Meghalaya Mines and Mineral Policy 2012 was already framed by the state of Meghalaya even before the directions were issued by NGT. In pursuance of NGT directions, there was draft guidelines of 2015 which were prepared by the state government. We thus are of the view that direction of NGT to declare mining policy state government cannot be direction of NGT to declare mining policy by state government cannot be said to be without jurisdiction. However, the state in its mind can only include those areas where it has jurisdiction under MMDR Act 1957 and rules of MMDR. So, in support of my submission, my lord, paragraph 91 of the Honorable Supreme Court clearly says that a state has power to frame the policy, necessary guidelines, my lord, and it is within the 4 walls of MMDR Act. The state is not denuded of, or the state is not without authority to frame the certain guidelines for grant of mining lease. That is paragraph 91, my lord. Kindly see paragraph 100, my lord, now.
Yes.
And 101, my lord. Section 4 of the Act contains general restriction on undertaking prospective and mining operations. Section 4 is couched in terms of an injunction. No person shall be undertaking any mining operation in area except under and in accordance with the terms and conditions of the reconsent permit or a prospecting license or all the case may be of mining lease granted under the Act and rules. Now, after quoting this, my lord, Section 4, my lord. Section 4 I have already placed on earlier occasion. Kindly see paragraph 101. The use of words, no person in section 4.1 is without an exception. There is nothing in section 4.1 to indicate that the restriction contained in 4.1 does not apply with regard to a person who is honor of the mind. Further, word any area under subsection 4.1 also has significance which does not have any exception. Further, phrase except under and in accordance with terms and conditions with a mining lease granted under this Act are also significant, which makes the intent and purpose of the provision clear and now. Section 5 contains restriction on grant of prospective license in the following words, my lord, and I have state government shall not grant a reconnaissance permit, prospecting license or mining lease to any person unless B, my lord, satisfies such condition as may be prescribed, my lord. So if the condition is, my lord, that you should have the mining area of 100 hectares, that condition cannot be said to be contrary to 5(1)(b), my lord. That power is there with the state government to prescribe the condition. So this is exclusively falls within the my domain.
Right.
Now 102, my lord, can you see 102? The proviso to section 5(1) is relevant since it contains a further restriction that no mining lease shall be granted with regard to any mineral as specified in para A of the first schedule except with the previous approval of central government. We in the present case are concerned with coal which is in para A of the first schedule. Lord. We are also here, Lord, concerned with
para A, yes.
In para A,
para A mineral.
Yes, and then you also will see 104 also.
Yes.
So when we read clause A and clause F, it makes clear that rules can be made for grant of mining respect to land in which waste with the government, as well as in respect of any land in which waste in person other than the government. We don't have issue whether if the mineral is owned by the owner of the land, whether the rules will apply or not, my lord. And your lordship will see also paragraph 116. Notifications are being issued time to time under MMTR Act and also Mines Act, my lord.
116.
That has been 116, paragraph 116. To the notification is also a mode of.
No, 116 above provision claim powers the district magistrate.
It may state to exercise power for the purpose, my lord. I am showing it that the notifications by notifications. The above provisions clearly empowers the district magistrate to exercise power and perform the duties of an inspector, but subject to general and special order of central government, which means that there may be some restriction on the power of district magistrate as acted by central government. In this context, Mr. Sri Dafte has referred to notification dated food under so and so under subsection 3 of section 5 of Mines Act, which is as follows, my lord. And notification, my lord, is upheld, my lord, by the central government, by the Honorable Supreme Court. And similar notification is also under, my lord, in Environment Protection Act, which is at paragraph 120, my lord. Can you see paragraph 120 also?
Yes.
Now we come to the Environment Protection Act 1986. A notification dated 14/9/2006 was issued by Ministry of Environment and Forest and exercise of power under section 3(3) of Environment Protection Act 1986. Section 3 of 1986 Act which provides for requirement of prior environmental clearance with regard to project enumerated therein. Scheduled to the notification listed the project or activities required prior mining minerals including 1A, but even for mining projects requirement of minimum 5 hectares was required for applicability of project. Substituting item 1A of the notification dated when a new notification dated 15/1/2016 has been issued. In place, new entry has been substituted in respect of coal mining area. So then you also will see that if the minimum area is less than 50 hectares, then who will be the authority? The purpose of placing this paragraph is this much only, my lord. By notifications, the conditions can be prescribed, my lord, and there is nothing illegal or wrong in prescribing the condition by way of notification for giving effect to various statutory enactments, my lord. And that power I have already under section 5A, my lord. Now kindly see in this light the judgment of the Honorable Supreme Court, because probably I was instructed that argument was also in respect of, my lord, the
smaller holdings.
The judgment, my lord, with regard to Yes, my lord, that delegated legislation and the issue of delegated legislation.
Yes.
If your lordship will kindly see the judgment of the judgment arising out of the Meghalaya High Court only, and Supreme Court, my friend will place that judgment of Gentia Inter Honor Association, my lord. That judgment, if your lordship will find. My lord, AJCC 492, my lord, and paragraph 23 straight away, my lordship, because in this case, Motor Vehicle Act and 21, my lord, Motor Vehicle Act was certain executive instructions were issued under Motor Vehicle Act. And the High Court said that without framing the rules, those cannot be given effect. That aspect was raised by the Honorable Supreme Court. The court, in paragraph 20, the core question which arises for consideration in these appeals is as to whether state government is empowered to issue any executive order in respect of matter required to be prescribed by the rule. Because in the Motor Vehicle Act, there was a requirement to prescribe by rules, my lord. Here there is no such requirement. Article 162 of the Constitution of India is unequivocal down, providing that executive power of states shall extend to the matter with respect to which legislature of a state has power to make laws. Such executive powers having in regard to the rules of executive business are framed in terms of Article 166. Clause 3 of Article 166 empowers the government to make rules for more convenient transaction of the business of the government of the state and for the allocation among the ministers of state business insofar as it is not the business with respect to which governor is or under the constitution required to act in his discretion. Memorandum was issued in the name of governor. It is not a dispute that it was authenticated in terms of clause 2 of 166 of constitution. Power was exercised by the state government under the provisions of the act. Said order was to remain in force till rules are framed or prescribed as in the prescribed manner. The provision of act mandates that unleaden weight and leaden weight must be determined indisputably. Weighing devices have to be provided for the said purpose. It is true that for the said purpose rules may have to be framed. It is however a well-settled principle of law that even in a case where a statute provides for certain things to be done, subject to rules, any action without framing of the rules would not render that action invalid. So if I take the argument of my learned friend that even under 5.1b, though this argument was not advanced by my friend, the prescription by the state government has to be under rules, Then also by executing instruction I can do it, But in my humble submission, there is no requirement to frame rules under 5.1b of the Act, So therefore, the standard operating procedure, which is based
the amount
on
of executive instructions. I mean, you see the amount of executive instructions only. They also are valid.
Yes, they are valid. This is my short submission, Even assuming I do not succeed on 5.1b, then section 18a, Lordship has already seen. Third, the repercussions would be, if I forward an application of 10 hectares to the central government, because prior permission of central government is required. Central government will not approve those applications, because central government has taken a view that scientific mining is possible only on minimum size of 100 hectares. So therefore, those applications will get stuck in the central government and whatever progress we have made so far. And we are on the verge of legal mining. All permissions have been granted in number of cases. More than 17 applications have been placed before the central government, and number of applications I am instructed to show have been cleared. So in legal mining can start any day. So to say that I have a right to start the mining on 1 hectare or 2 hectare or 4 hectare of land, in my humble submission, is not in consonance with the statutory regime which we have and the notification issued by state government and even direction issued by the state government. Even therefore, the judgment which my friend has relied has no application to the facts of the case. It was with regard to challenge to the power of the central government to delegate power on the state government to fix the rent to be collected from tenants. The maximum rate was fixed, that was 1/4 of the entire rent, and conferring power to state government to even lower it.
Yes.
So that the delegated legislation was under challenge. Here there is no such challenge.
Yes.
So therefore all have to submit.
Your Lordship, I have heard the submission of Learned E.G. He has referred to Section 5. Okay.
Yes, one thing, Mr. Sangma, you have to, yes, see, firstly, that the artificial said 5.1b, such conditions may be prescribed. Whether it's SOP, can be such conditions may be prescribed, and his other
it is
submission is that
effective.
Even if 5.1b is in doubt, then under Section 18 of the MMRD Act,
whatever
it's permissible for state government to.
Section 20 capital A, sorry.
Section 20, yes.
Capital A.
Section
20 capital
20,
A.
yes. Powers on the government to issue directions. Yes. Yes.
But in this matter, Your Lordship, there is no direction. It is a meeting between the officer of the state government and a meeting between one officer of the government of India. And they have formed a memorandum of minute. And on that minute only, they have said that, yeah,
no, you have to show to the court that, as you said, that there is no source of power.
Yes,
that enables them to issue the SOP, and until there is some adherence to the act. Now, did that amount as prescribed by the state under 5.1b?
It is not, Your Lordship, because there is no source of power. I will read their notification, Your Lordship.
Where's the notification?
Page 27 of my
of your petition.
Petition, Your Lordship. The Government of Meghalaya hereby notify standard operating procedure here in after SOP for processing the application submitted under the Mineral Concession Rule or as amended from time to time for obtaining the previous approval of the central government or grant of prospective license and mining license for coal in the state of Meghalaya. Normally, it is just an instruction, just a circular, just a resolution of the government, Your Lordship. It is not a statutory rule. It is not a statutory instruction. So,
one thing, Mr. Sama, will that amount to executive instructions? This SOP is notified also.
Instruction cannot go beyond the provision of the Act, Your Lordship. Instruction should be in consonance with
the Act. Does not provide the minimum.
No.
It provides the maximum, yes.
It cannot go beyond the provision of the Act. Any instruction, any circular has to be in consonance with the Act, with the provision of the law, Your Lordship. That is my own main grievances. Rather, they should have license. They should protect the environment.
No, have you examined Section 20A again? See. One second. Just to. But this meeting was held between central government and the state authorities.
That cannot be the ground to alter the statute, Your Lordship. That cannot be a ground to alter or to change the statute. That is why I have said in my previous submission one Supreme Court order. And I have another.
What is this?
Yeah, Your Lordship. I will read to para 10, Your Lordship.
Which judgment?
Judgment is
Ashok Ram Prahad.
Press Court, Maradiam Limited.
You given them copy?
Yeah, given, Your Lordship.
Citation, I would request friend to give me citation. Oh, Indian Parliament. Okay.
Para 10 and 11.
This from which High Court?
This is in Supreme Court. Your
Madras
Lordship.
High Court.
Yeah. Gujarat High Court and Supreme Court.
Yes, yes.
May I read, Your Lordship?
Yes.
The Honorable Supreme Court, in a similar circumstances, in the case of Commissioner of Center Excise, Bhojpur versus Ratan Melting and Wire Industry, 2012 STR 416 SC, has held as follows. Circular and instruction issued by the board are no doubt binding in law on the authority under the respective statute. But when the Supreme Court, in this thing, the court or the High Court, declared the law on question arising for consideration, it would not be appropriate for the court to direct that the circular should be given effect to, and not the views expressed in the direction of this court or the High Court. So far as the clarification circular issued by the central government and the state government are concerned, they represent merely their understanding of the statutory provision. They are not binding upon the court. It is for the court to declare what the particular provision of statute says. It is not for the executive look at from another angle. A circular which is contrary to the statutory provision has really no existence in law. 11, Your Lordship, it is held that circular cannot prevail over the statute. Circular are issued only to clarify statutory provision, and it cannot alter or prevail over the statutory provision.
Yes.
Now I read again to another judgment. Ashok Ram Farhat.
But it's not, anyway, yes, please read.
Page 23, Your Lordship. Para 23.
Para 23?
Yes, Your Lordship.
Yes.
The respondent further submitted that endeavor of the appellant to rely on government resolution dated 25/1/1990, 29/7/1993, 17/2/1997, and claimed that Rule 2 of the 1984 rule has no relevance is fallacious, as government resolution cannot override the rule. Further, the resolution neither speak about the promotion to the post of DFO nor about how the seniority has to be gone from ACF appointed by promotion or by nomination. Then 25, the first sentence, in service jurisprudence, the service rules are liable to prevail. There can be government resolution being in consonance with and expounding the rule, but not in conflict of the same. Not in conflict of the same. It should be consonant and corresponding with the statute.
How is it in conflict?
In conflict in the
Yes,
sense
because
there is no minimum, Your Lordship.
the Act is silent.
Silent.
Now, suppose the Act has provided a minimum, or suppose a maximum, and the government says that maximum is fine. That is a conflict. Now, whether in furtherance of an Act, taking into account the circumstances and by power vested under the MMRD Act.
This
right?
is an
now
exercise
it can be taken. And It is not a question of just executive instruction or circular. They are notified. There's a notified SOP, which is pursuant to a meeting, which, whether now we have to test it. Now your submissions are that it cannot be a meeting which is under Section 20A because there are no direction of central government to the state government to issue such instructions. Correct? Is that your submission?
It is not correct, Your Lordship, because
now how do you say conflict? How do you say conflict? Conflict only come if you say that
how
since
the two officers can change the
only if you say that
law,
since the state has not.
That is my submission.
Listen, your only argument with that, since the Act does not prescribe a minimum,
does not prescribe.
That means that there can be no minimum.
No minimum at all.
That means you have 1 inch of land. Now, suppose you go to your backyard, you think that you have coal there, you'll apply for prospecting license. What will be the reasonable classification then?
Your Lordship, it is for the authority to examine.
That's why they have examined. See, they have
now
examined
prescribing 100 hectare, according to my views, it's direct conflict with the law, Your Lordship.
So you feel that everybody is like open to everyone who thinks they have some mineral in any part of the land or whatever land to make an application prospecting license for reconnaissance and for mining lease.
In my humble opinion, they should be allowed to apply. They should be allowed to apply.
Even the land is just a few square feet also.
Whatever may be, Your Lordship, but 2 square feet, nobody will come. You know very well, Your Lordship. Nobody will come for 100 feet, 100. At least they will have some. At least 5 hectare, 10 hectare, 30 hectare.
So by a submission, you think how much should be the minimum? What should be the minimum land permitted for prospecting?
Whatever it is for the state government to examine.
So they have examined, and after that they said that it will not be possible. It will not be possible to do scientific mining in a land which is one. See, the court is not here to put down any or to make a sort of examination on what will be the reasonable amount. The only thing we look is the reasonableness of the decision of the state government.
But 100 is not reasonable, Your Lordship.
You show that then, by what's been done, that it's absolutely
even
illegal.
in that meeting also, they understood that 100 hectare is not. It is to be reduced further. Even in that meeting, in that memorandum of meeting, Your Lordship.
Let's see where's that. Let's examine it again. In page 10 of the affidavit.
In their affidavit in opposition, Your Lordship. Para it. With regard to minimum area, he informed that many owners have
Where reading from?
From the affidavit of opposition.
Yes, it starts as Secretary Mining Geology. Which part are you reading from?
Para page 11. Para it.
Okay, read para it.
Yeah. Secretary Mining Geology, Government of Meghalaya expressed his thanks for his very important meeting. The state is rich in coal deposit with 570 million ton proven good quality of coal deposit in Meghalaya, and the state government has already discussed with various stakeholders to evolve suitable coal mining method and has empaneled company for exploration, prospecting, preparation of geological report, and mining plan. With regard to minimum area, he informed that many owners have coal mine area about 50 hectare or less. The hectare proposed to reduce the minimum area to 50 may be examined technically in future. He emphasized that it is important to start coal exploration and request cooperation from CIL. Your Lordship, see, in the meeting also, they understood something wrong here.
Who understood? He emphasized the 160 geological reports and my report.
I understood, sir. Understand from this.
So
Your Lordship, my point is 100 hectare is not fixed in a higher side. And this has no basis under the MMDR Act.
Exactly, we understand that, but what will be reasonable classification? This court cannot examine that technical aspect. We're not experts, right? And if the report says that, where that says for scientific mining, 100 hectares is necessary.
Your Lordship, I may say to myself, for so long, right from British time, these coal miners, small coal miners, they are having their livelihood.
Don't go on compassion. The court's not to look whether you're old, you're poor, or thing. You go on law. This is purely in a law point. You're putting forward arguments that this is illegal. So show the illegality.
I have shown my legality supported by 3 Supreme Court judgments, Your Lordship, and this 100 hectare.
No, the thing is that you see, Mr. Samma, we have to make watertight case that this circular or this executive instruction SOP is violative of the MMRD Act.
Yes, it is violative.
Violative, and not only in the sense that because it doesn't prescribe a minimum area.
No.
Now, prescription minimum areas is enabled by you go section 5.1b. It enables that. Now, if go back to 5.1b, we read it together. Okay. See, restrictions on a grant of prospecting license of mining leases. The state government shall not grant a reconnaissance permit, prospecting license, or mining lease to any person, read B, satisfy such conditions may be prescribed.
Yes.
So these are conditions that have been prescribed. So if whatever they do, notwithstanding the area.
Hectare, I am not challenging those conditions, Your Lordship.
You are challenging the condition only.
No,
the only
100,
condition.
100 hectare. 100 hectare.
That's the condition. The condition by the SOP is 100 hectare. Now this is what the condition is prescribed. So how will you get over this? And if you can't get, if you can show the court that yes, that it's not as per 5.1b, then how do you get over 20A? How will you get over the?
In the 20A does not give authority to central government.
It has to be based on solid legal arguments. You just cannot say that it's not reasonable. 100 is too big. We can't have that kind of arguments. You have to show that if we are challenging this SOP, it has to be on solid legal foundation. That what the SOP has prescribed is not contemplated anywhere in the Act. That is not contemplated anywhere in mineral concession rules. That the contemplation of the Act is for so and so forth. And what is the legislative intent of this MMRD Act of not prescribing a minimum area prospecting? Not just to say, keep on banging that is unreasonable. It's unreasonable, maybe. It's unreasonable for a person to have 4 cars. But then like the Motor Vehicles Act doesn't say anything about a person having, that a person is supposed to have only 1 car registered in his name. What is reasonable, what's unreasonable? What does the law allow? Now, as per, you just look at the law. You look at restrictions on grant. Now, see, satisfied can be prescribed. What is conditions? Given a big latitude. If we are challenging it on another ground, which this court will not sitting advisory capacity, there are other grounds to challenge it, which maybe you have not discovered.
Give me some more time, Your Lordship.
It's a question of time. It's a question of you have to understand, you come in a legal foundation.
Yeah.
It is purely a question of law also, whether the state government has the power to prescribe these conditions before anybody can apply for a prospecting license. That's all. And a prescription given by the state government is that to enable scientific mining in a proper fashion, every prospecting license should have land of at least 1 square kilometer to make it viable. That's all. So that's prescription. Now you've come before us, if I correctly understand you, is that you say that I have a small holding. Now this prescription is illegal. That's it. So if it's illegal, you show illegal, you say it's conflict with the Act. Conflict with the Act means that there has to be something in the Act which, does not allow the state government to make its prescription. By saying that the Act is silent, it prescribes maximum, doesn't mean that the other conditions can be prescribed to state government to prescribe the minimum area required. I'm sorry if I talk too much, but that's the only thing that's running in the mind of the court. That unless you come up with some substance to show that, yes, cannot be a complaint in the wilderness, We understand. It may be wrong. It might, in the first place, it's wrong. Maybe it's wrong. Maybe it's shut out all these small landholders or landowners. But how is wrong?
But my point, Your Lordship, since the MMDR Act does not prescribe minimum, that is my only thing, Your Lordship.
But then, does anything, tie their hands from prescribing a minimum area? That is what you have to show, that there is a restriction on the state government from prescribing any minimum area for prospecting.
When the Act does not prescribe, then it is...
Act is general. That is why the Act empowers state government to make prescriptions, because suppose you open cast mining of iron ore. Maybe the minimum area there might be only like 5 kilometers. Now you cannot, unless it has to be rules framed under the Act to classify for Group A, Group B, Group C minerals. You understand? You can't go to a general provision to extract a detailed definition. That can be done. Because the Act General is made 1957. It just says, okay, fine, it cannot be above this maximum thing. But does it prescribe minimum? Why? Because coal is not only mineral. There's many other minerals.
But this is for coal.
This is for coal, yes. But that is what? You try to satisfy the court, otherwise it becomes very difficult. Sure, that is, have you challenged the SOP?
Yeah, I have challenged
Where
the
is your
SOP.
position?
I have challenged the SOP.
The entire SOP?
Yes. But my main challenge is on 100 hectare, Your Lordship.
Now you ask me rat hole mining be allowed also.
Yes. Because in Meghalaya...
No, you don't go by sentiment. Long time ago, everyone used to light a fire by rubbing two stones. So you say that now no one should use, should use by 2 stones only.
Open cast mining not possible.
You prepare it well.
Meghalaya,
I mean, you try to show something.
If it is open cast mining, then our district will
be very destructive. Correct. You come up with a better. See, you're very lucky to have such an interesting case to deal with.
Yes.
Many lawyers won't get such a case, which examines the legislative competence, of the state government prescriptions, and in the context of what's happening here with mining. So you're looking for justice. You first have to do justice to your brief.
Yes, I'll make the justice.
Yes.
Give me some more time.
You prepare. We'll give you 1 week's time. Before we will close it today. Yes, just after 1 week to enable the petitioner to prepare the case further. Yes.
Much obliged, Lordship.
Daily, hearing 12.
Excuse me. One more fine. Huh?
My Lord, a detailed and elaborate reply, my Lord, has been filed today.
We're not accepting any. We'll close the matter. You will pass orders. There are serious allegations against you. I don't think you should appear in the matter any longer also. I don't know how. Should we close the matter? What real affidavit? We didn't ask any affidavit.
No, we have read last time that we are going to reply the objection of the state, my Lord.
But already affidavit has been filed by the. Where's that affidavit filed?
Yes, already filed. Copies has been served to the state. Only on the state respondent we are replying.
When you filed it?
This morning, Your Lordship.
Why you file this morning? When you take time? No, filed by respondent 6. Respondent 6 whom?
The state, the state.
Number 6.
Yes,
This is
the
state.
state respondent. In their objection here, my Lord. And in this elaborate and detailed...
1 second. Please, 1 second. Ka miss case ka petition miss case the?
Yes.
Miss case petition hai ran. Orders. Miss 96. Okay, yes. Miss case was filed by whom?
Filed by the applicant, Your Lordship, this EMO Sora.
Okay, this miss case was filed on?
Miss case 96.
5th June 2024, okay. Then, affidavit been filed by?
Objection has been filed by the state respondent.
168.
And even by the respondent. But we have replied seeking permission from the court to reply only on the state respondent objection, Your Lordship.
I don't know what is she doing. You already filed it on the 1st of July?
Lordship. 1st of July, that's our reply to their affidavit, Lordship.
Number 6 is whom?
I'm for respondent number 6, Lordship. The main petitioner and the writ petitioner.
It's very confusing. Yes, 75 to 80.
In the misapplication, Your Lordship, the petitioner is the respondent.
Record wrongly they. After on behalf of respondent number 6 been filed, being record certain fact documents filed by whom?
Lordship, that is our affidavit, Lordship.
This is highly confusing.
May it please your Lordship.
6. Who's 6?
Lordship, in their miscellaneous application, they filed 2 miscellaneous applications, 85 and 96. We are on 96 right now, Lordship. I have filed.
You're number 6 and 96.
Lordship.
And in the main case?
In the main case, I am the petitioner.
We are the petitioners.
This case is filed by?
This Imam Sora.
Filed by Imam Sora. Who's the respondent number 1?
Respondent number 6 in the main case, Lordship.
He's 1/6 in the main case.
Yeah, Lordship.
That is the problem. Objection filed, say respond, okay. Objection filed with respondent number 6. After number 6, huh? So, where's the order sheet, young man? This case, where was the order allowed to file objection? To file, huh?
The last order.
Yes. I got it. Sure. Huh? But shot them told me. Yes.
If I may assist your Lordship.
See, there's no permission allowing to file an affidavit to this. It's your miss case.
Yes, but Your Lordship, they have filed on that day an objection is very elaborate and it
So?
is on the same morning. And I have asked Your Lordship in
Where
open
is
court
the
that we would
body
like
in
to
order?
file an.
We can't have
we can file a
multiplicity of-
reply, and Your Lordship has allowed me also.
It's
Your
not
Lordship.
reflected in the order. Not reflected anywhere. Objection is on 25, so says 15.6. Have to be our page of file being under
List the matter on 1st July to allow the state respondent and the other respondent to obtain instruction.
Yes. And 1st July,
A perusal of the objection. On this day, Your Lordship, an objection has been filed in which a report, inquiry report, has been also included in that objection, and regarding the non-maintenance of the.
now where's the permission sought from the court to file that to the affidavit to file rejoinder?
On that same day, when they
It's not
file in the
recorded
same
here.
morning, that same day, I have seek permission, and Your Lordship also have allowed me, Your Lordship, that yes, since I have received on the same morning, I need to go through and get.
We need to go through, yes. Objections on behalf only.
And
18.6 objection behalf of state respondents
Yes,
1.6
and if we go
in
through
MSK
these,
96.
this
Then-
reply, Your Lordship, will see that we have been cornered. And it is their frame and grounds only that we have only complied, Your Lordship. And these are official documents
What
attached.
corner? Why did you ask them to charge 200 going one way to another way? Simple as that.
Been overly diverted, Your Lordship, in this case, whereas the writ petition and the main writ petition, Your Lordship, the status of the road only has been questioned. And even when in the first, after the interim order also, a misapplication from the petitioner has come up, Your Lordship, objecting to the maintenance of the road for 1 day. And on that day itself, in that order, Your Lordship, in my annexure.
I don't know. This court doesn't remember anything.
In my
now.
annexure, this court has said that by the next date, the status of the road should be
I
clear.
don't see any in the order sheet, any order allowing to file, and it's your miscase. Objection has been filed. You're filing rejoinder to the miscase.
Not
Rejoinder to the
rejoinder, a
objection.
reply. Yes, always a rejoinder. Yes. Your Lordship, in the first annexure itself, Your Lordship, when they have questioned regarding the maintenance of the road, Your Lordship has given us a favorable order, Your Lordship, saying that we can maintain the road for that day, and the next day the road shouldn't be operative. And a very important point here. It is to be noted that it is expected that by the next day, the status of the road as to whether
We're
it
not
is
concerned about
maintained
that. We're not concerned about
should
that.
be clarified
We're
by
not
the,
concerned
by
about
the
the road now.
parties.
We're concerned what are the allegations made in the affidavit in the objection file?
We have
on behalf-
we
yes.
have replied that
Let's
in
see,
this.
what did it say? What did he say? Yes.
First and foremost, Your Lordship, it's saying that the road was not maintained even from the very first instant that the interim order or the order for maintaining of the road is being allowed by the Honourable Court. But when we maintain, the moment we receive it, in the same month itself, Your Lordship, it has been objected, and because of that, we have come and replied to the misapplication filed by the petitioner, and this court has allowed us to maintain the road with a strict direction that by the next date, that is the main contention of the writ petition, is whether the
Please
road
stop.
is
Now,
a
please stop.
status
The
of
court is
road or not.
examining. Please stop. Don't want any other adverse orders to come against you all.
Please, Your Lordship. Light. Bow down, Your Lordship.
Just sit down first. Become a mockery of the entire thing.
Yes.
That's why our state can never go forward. You give a handle and instead of working in public interest, everything's self-interest. Have records maintained since that time when the courts had maintained records with regard to the
Yes, we have all
money
the
received.
counterfoils. We have
All accounted for.
all the counterfoil receipt. We all
No,
have
not
the
counterfoil,
records.
the records.
Yes, the records.
Your cash book. Now
Everything is
every
being
money
maintained.
that's been received.
It's all in the inquiry
No,
report.
please. All the money has been received by the CM Sora and running the road. Is it on record?
Yes, Your Lordship. All these submitted in the magisterial
Have
inquiry
you
also.
put it in your objection? Where's
No,
that in
Your
your?
Lordship,
Where's
it's
that
already
in
in
your
the
reply?
objection of the
Because serious
state.
have been made against the misuse of money. The whole of where we said about the. Have you annexed the documents?
It's in the objection of the state. It's all in the inquiry, magisterial inquiry. All these submitted to them, Your Lordship. The accountant also has appeared before the magistrate, and all these submitted. State Bank also.
Yes, but the thing is that what's given inquiry is that the CM has made very little effort. They have not maintained proper records with regard to collection of tolls. And he maintaining the whole Soros MCF from the collection of his tolls. Whole Soros MCF has been maintained by collection of his toll from this road. Is that correct? You read the disposition. Contract on some money collected was used to pay 23 who are employed 15,000 per month. Salary myself 50,000 per month. Same Khana 30,000 per month. Secretary Hima 25,000 per month. Honorable to 12 ministries 5,000 per year.
Okay, objection. The annexures of the road attached in the objection, Your
No, this is on oath is the deposition of your respondent.
Yes, Your Lordship.
That means the whole money collected is used to for a salary.
It's the source of the
Source income. How much you used to repair the road? Nothing given.
It's there, Your Lordship, in the position of the then minor contractor.
See, at present, an agreement with Sri Tamdor Nadan was entered on 16 August 2020 to repair the road at 5 lakhs per month for a period of 3 years. 5 lakhs per month period of 3 years.
No, per year, annually.
5 years per month. 5 to 12, how much? 60 lakhs per year for maintenance of the road. And how much payment you're using the other payments? Payment and then 23 volunteers. Who are these volunteers? 15,000 per month. 15,000 per month. Then salary myself 50,000. Same kind of 30,000.
Your Lordship, in my reply, the number of vehicles
We'll hear it. I think there's some also even against the council.
depicted by in the objection is incorrect, since the slip has been fake slip also out there, and FIR has been lodged last year also.
Why did you charge 400?
203, 200 exit.
Where does it say? Did the court
That's
say
what-
anywhere?
that's
Did the court
what-
say anywhere entry exit?
No, Your Lordship,
Then-
that's what the interpretation.
Then
That's why we
what
bow and
interpretation? You'll
apologize
pay,
on
you're in
that, Your
contempt.
Lordship.
Are you the one who give advice?
No, Your Lordship.
You'll go to jail.
No, Your Lordship.
Yes.
Your Lordship, here in my reply,
No one reply. We're not doing reply. Yes, Mr. Shulai.
Lordship, if Lordship kindly take the objection, though no permission was granted, which was filed today, Lordship, in para 6.
Too much really.
Kindly come to para 6.
Permission was granted also. What objection?
Lordship, the objection filed by them today, Your Lordship, to the affidavit filed by the state, Your Lordship, by the Deputy Commissioner, Your Lordship.
6, the applicant by state custom told her however, applicant collected amount usual 200 as usual. For going to instead answer money as was suggested, advised by the who's officers, who's the one who advised?
this is the annexures.
advised?
We are bringing on record, Your Lordship.
Who advised? Who's the SDO?
Now,
Yes,
Lordship,
the then
You asked him to
SDO.
appear. Who's SDO who said to charge 400? Against orders of the court, he said 400.
No, Your Lordship. Kindly
See in paragraph 6 of the objection.
Lordship, yes. Is sir understood by the applicant as the same was suggested and advised by the office of the subdivisional Lordship. This is completely Lordship against the record. There was a statement, Your Lordship, made by this Lordship. Kindly have a look at the report of the.
You'll not even
We'll
take
just see the
we'll
annexure, Your
consideration this
Lordship. We'll
objection.
just see the annexure number 6, number 4, Your Lordship.
An objection has been filed to the affidavit filed by the state respondents in miss case number 6.
Miss case for
miss case 96.
Yes.
Yes. An application has been, an objection has been filed to the affidavit filed with state respondents in the instant miss case.
MC WPC 96 of 2000.
Order sheet does not disclose any permission being granted to the applicant to file an objection. However, for the end of justice, the same is taken on board and on record.
My lord, only a small submission. My lord, it is evident, my lord, against the rate of 200 rupees granted by lordship, they have collected 400 rupees.
400, your lordship. That is
so, my lord, let there be a direction, my lord, that the excess amount which they have withdrawn, let them deposit before the registry of this honorable court.
No, that order will follow. Don't nod. That order will follow. The thing is that there's been sort of disposed, even Sora has been misled by I don't know who. That's the thing. We'll ask him to come out here personally. Mr. Kanta, he's been very severely misled wherever he is. What's his age now?
80, your lordship.
Something is wrong. Then orders will follow. Go and appeal to whatever, then we shall see. Whatever the court has to do, will do. This is a matter after 1 week, yes. Anything, you just examine objections.
Lordship.
Yes.
Does it deposit excess?
No, we'll pass orders. We'll ask for the whatever. We'll not say what we ask for, but we'll ask for. Otherwise, we can't let these things go on this way. The judicial institutions have to be protected. The district council should protect them.
Yes.
They also are be allowed to survive, but they should not be exploited. That's all.